Okay, let's get started. Welcome. I'm Lane Wyndham, the Associate Director of the Kalmanovitz Initiative for Labor and the Working Poor at Georgetown University, and I'm pleased to welcome you to today's webinar, Envisioning Just Cause Employment and a New Social Compact. We're recording today's event, broadcasting live on Facebook. Hey, so we want to know who's here today. I would encourage all of the group to tell us who you are. Go to the chat function at the bottom of your screen, type in to everyone your name, your city, country, if you're outside the US, and your organization in the chat. Our format for today's meeting is going to be a roundtable discussion with our panelists. I'll begin the discussion by posing some questions, and then we'll address the audience questions. You can submit those at any time through the Q&A function or chat at the bottom of your screen, either one. Today's webinar is part of our New Social Compact project. We began this project in 2020 asking, what world do we want to create in the pandemic's wake? The project envisions, defines, and lays the groundwork for a new social contract that centers working people and is based in equity. We will have a major virtual convening June 2nd and June 3rd called the Pandemic Worker Wave and a New Social Compact. Stay tuned, and you can find out more information about that in the link that we're going to post in the chat. Registration is not yet open, but it will be soon. So we're talking today about at-will employment, which of course is a cornerstone of our current social compact in the United States, though we don't often think of it as that. We often take it for granted as a kind of given. At-will employment means that employers may fire an employee at will without just cause, provided there's no contract or union. There are some major exceptions like anti-discrimination law or laws against firing whistleblowers. The US employment system is weird and that nearly all of our employment, with those exceptions, is at will. Most nations require that workers are given notice for when they're terminated. Many require that employers have a good reason or just cause for firing workers. Many US workers think they have far more rights than they do. They don't realize how little right to their job that they actually have. So I'm a historian, and I long thought that this at-will practice in the US dated all the way back to master-servant relations in Old English law. It does have some roots there, but in fact, the accepted practice in Old English law was that employers kept people for a year. At-will employment only became settled legal practice in the US in the late 19th century, even as other nations like England, etc., were headed in the other direction. Key to our doctrine was this one guy's treatise, Horace Wood, who's a former railroad lawyer, who falsely argued that US legal precedent universally recognized at-will employment. It's not the case. There were other precedents that he ignored. Nevertheless, many states took it up. The Supreme Court used the at-will doctrine in decisions. The historian Leah Vandervelde has shown that the US made this turn to at-will employment in the context of debates about employment during Reconstruction, when elites sought to keep control over formerly enslaved people. This was also, of course, a period of intense industrialization, when workers were battling and striking with the employers, like in the railroad. So at-will employment in the US has a particular history. It's rooted in worker activism and enslavement, and as we will discuss today, has enormous implications for workers' ability to build power within our current social compact. So to help us envision a just cause employment standard and what that would mean for our new social compact, we're going to turn to our panelists. And I'm going to introduce them now. Guilherme Drey is a professor of labor and comparative law at the University of Lisbon and partner at Macedo, Vitorino and Associates law firm in Portugal. He's also a committee member of our New Social Compact Committee. He is one of the authors of the Portuguese Green Book on the Future of Work. And we are very excited to hear about how just cause employment works in Portugal. Hugo Okere is the policy director for the Raise the Floor Alliance and is leading the campaign on at-will employment in Illinois. For instance, he is co-author of the Secure Jobs Act bill in Illinois. He also has worked there to pass a living wage in the city of Chicago, expand the earned income tax credit, and help create new worker protections for domestic workers. Benjamin Sachs is the Kestenbaum Professor of Labor and Industry at Harvard Law School and a leading expert in the field of labor law and labor relations. He teaches courses in labor law, employment law, and law and social change, and his writing focuses on union organizing and unions in American politics. And Irene Tong is the senior researcher and policy analyst at the National Employment Law Project. She is the lead author of a fascinating study by NELP, Just Cause Job Protections, Building Racial Equity and Shifting the Power Balance Between Workers and Employers. And Lily just put a link to that report in our chat. Okay, so without further ado, let's turn now to our discussion with our panelists. So I'd like to start by posing a question, a couple questions actually, to the whole group. As I was saying, US workers, often accept at-will employment as just the way things are in this country. Countries all over the world have a different standard. How does at-will employment impact workers? Is a just cause employment standard an important element of a new social compact? And if so, why? So how does it impact workers, and how can we understand it as part of a new social compact? So Irene, I'm going to turn to you. You can perhaps bring in a little bit of what you found in the report. Tell us about the impact of at-will employment on workers.
Thank you, Lane, for that important historical context you provided and for this question. So what we know from national survey data is that unfair and arbitrary firings are extremely common in this country. Almost 1 in 2 workers in the US have this experience at some point in their lives. And Black and Latinx workers of all educational levels report higher rates of unfair dismissals overall. Of workers who've been fired, 42% aren't given any reason for their discharge, and only 1 in 4 are given a fair warning and a chance to improve before being terminated. But beyond the harms of actual job loss, what's more subtle and equally harmful is how the at-will relationship fundamentally shapes power relations between employers and employees. For all workers, not just workers who have been fired. At-will defines the employment relationship at its root as one of subservience, enforced through economic coercion, and not as a relationship of mutual benefit, or even as one between parties who can meaningfully bargain with each other. When we think about job quality, often the first things that come to mind are wages and benefits. However, the day-to-day experience of job quality for workers is, of course, much more nuanced. And under at-will employment, workers are forced to make risk calculations on a daily basis due to the lack of job security and power. Will I lose my job if I don't prioritize my work over my health or over family obligations? Should I skip breaks, work overtime even when I don't want to, not take sick or vacation days, etc., to avoid being fired? And the survey data reflect all of these concerns, which largely arise from the lack of a transparent, predictable, and consistent legal framework for employment. So at-will is really the engine that drives the continual race to the bottom in job quality in this country. And Black workers, immigrants, workers of color, and women who have historically had the least amount of power in the labor market are the most impacted. So we can look to the experience of Black workers as an example. Research has shown that employers are often more skeptical of Black workers than white workers that they hire, and that they more heavily scrutinize Black workers than white workers on the job. So Black workers must meet a higher bar of performance than white workers in order to keep their jobs. And because Black workers are more closely scrutinized, it increases the chances that errors, large or small, will be caught, and that as a result, Black workers will be let go. In other words, Black workers often don't get a second chance. And in the absence of any kind of framework requiring transparency or fairness in discipline and termination, it's very difficult to document this when this happens. But even if a Black worker can document that they were treated unfairly, most of the time, this kind of unfair treatment doesn't qualify as discrimination under the law because you have to be able to prove discriminatory intent. And the vast majority of discrimination claims fail for this reason. And psychological studies show that most people, including jurors, are very reluctant to ascribe discriminatory intent to other people. However, while they're not willing to say that something is discriminatory, they are willing, much more willing, to say that something was unfair. But under the current at-will doctrine, unfair isn't illegal. So the kind of unfair treatment experienced by Black workers can be devastating when compounded over the course of a career. After being fired, Black workers return to the pool of unemployed workers, where data show they'll have a more difficult time finding work again than white workers, which leads to their next employer to be wary as well. And in the meantime, white workers are less scrutinized and as a result enjoy longer tenure on the job, which leads to a stronger work history, more skills, higher wages, et cetera. What then does a just cause law entail, and how can it help to interrupt the cycle? Just cause law provides a basic framework for fairness and transparency in discipline and termination. The most recent laws adopted in New York and Philly dictate that a worker is fired with cause only if five conditions are met. First, that, First, that the employee knew or should have known of the employer's policy, rule, or practice. Second, that the employer provided relevant and adequate training to the employee. Third, that the employer's policy, rule, or practice was reasonable and applied consistently. Fourth, that the employer undertook a fair and objective investigation. And fifth, that the employer utilized progressive discipline methods according to a written policy on such discipline. So the bottom line is that just cause gives workers more individual power on the job to push for better working conditions on a day-to-day basis. But I think what's also important to emphasize here is that our campaigns to win these policies are really vehicles to communicate and move a change in cultural consensus, a cultural shift in how we understand this basic relationship between boss and worker, to a relationship of mutuality and respect, as opposed to of subservience. And at its heart, that's what this movement is about. So thank you all. I'll pass it back to Lane.
Terrific, thank you. And I really like that framing in terms of thinking about it, not only in the specifics of the policy and the legality, but the culture and thinking about the issue in a different way. Ben, can you, speaking of law, can you tell us a little bit more about what is the impact on workers of the at-will employment, and speak a little bit about just cause's role as we rethink the social compact?
Yeah, so a bunch of what I was going to say is actually covered by Irene's excellent answer to your question. So forgive me if I repeat a little bit of what she's been over. But as you said at the outset, Lane, the default rule in the United States is employment at will. That means that unless there's some other protection in place, workers can be fired for good reason, bad reason, or no reason at all. This contributes to a massive power disparity, as we all know, between employees and employers. And when employees know that they can be discharged at will for nearly any reason at all, they rightly come to fear, let's call it, displeasing the boss. In an at-will regime, workers learn that displeasing the boss can mean the end of their ability to support themselves and their families. The consequence of that dynamic really can't be overstated. It helps explain, for example, why workers too often acquiesce to abusive work environments, something we've learned painfully about over the last 5 years. It helps explain why workers don't fight harassment. It helps explain a lot about why workers, and women workers in particular, hesitate to ask for better wages and fight for better working conditions. And of course, it helps explain why workers are often afraid to organize a union. So Jay Feynman says, in recognition of this dynamic, that employment at will is, quote, the ultimate guarantor of the capitalist's authority over the worker. I think that's not an overstatement, right? So more particularly, and this is why when we did our Clean Slate for Worker Power project, we ended up recommending a federal move to just cause protection. At-will employment actually undermines the effectiveness of laws that explicitly give workers rights better than at-will employment. So Title VII, the FMLA, the ADA, the National Labor Relations Act, all tell employers that you can't fire workers for a set of reasons. But against a backdrop of at-will employment, the effectiveness of these critical protections is undermined. So how does that work? Take, for example, Title VII. That statute explicitly prohibits employers from firing workers who protest race discrimination. So an employer by statute may not fire a worker who protests race discrimination, but under the at-will rule, the employer can fire the worker for nearly any other reason. So the at-will rule lets employers rely on, or more accurately, manufacture a huge range of other explanations for a discharge that's really based on race, including, for example, that the employee was too late, often too late, the employer had a bad attitude at work, the employee didn't dress appropriately. All the kind of traditional at-will firings can be used to justify a discharge that's actually based on race. Now, to be sure, an employer, if faced with an allegation that she fired a worker for race or for protesting racial discrimination, would have to prove that its asserted explanation was pretextual. But the at-will rule gives the employer great latitude to put forward a wide range of ostensibly non-pretextual reasons for the discharge. In fact, the range of ostensibly non-pretextual reasons in an at-will world includes any reason for the discharge other than one explicitly prohibited by law. So replacing an at-will employment regime with a just cause rule would help correct both of these problems. If employers are required to show a good cause in order to justify firing someone, employees will know that simply displeasing the boss can't result in job loss. They would know that the employer has to have some good faith, objective, and job-related reason for firing them. So this move from at-will to just cause can help rebalance the power dynamic that plagues the employment relationship today, and thereby empower employees to oppose discriminatory, abusive, inequitable, unjust workplace practices. Also, under a just cause regime, the anti-retaliation guarantees of all these statutes that I named, Title VII, the FMLA, the ADA, and the National Labor Relations Act, are likely to be more effective. That's true because employers are less likely able to be reliant on pretextual reasons for discharge, right? Put simply, it's much more difficult for an employer to justify a discriminatory discharge, one based on race, one based on disability, one based on accessing family leave, one based on organizing a union. It's much more difficult for an employer to justify that kind of discharge in a just cause regime than in an at-will regime. If somebody's fired for union organizing, it's harder for the employer to justify it if they have to come up with a good reason for the discharge than if they can come up with any reason for the discharge other than union organizing. That's why the Clean Slate report prominently recommended a move at the federal level from at-will to just cause protection.
Terrific. And maybe, Lily, if you get a chance, maybe we can drop a link to the Clean Slate reforms, to the suggestions into the chat so people can actually look at that. So thanks, Ben. So Ugo, I'm curious, you have been helping to lead the charge in Illinois to really tackle at-will employment. So why don't you weigh in on this question of the impact of at-will employment on workers, and why did you and the rest of the coalition members decide to fight this battle in Illinois?
Absolutely. Thank you, Lynn. And thank you, Ben, for really, I think, laying out the intricacies of the issue with at-will employment and, how in many ways, when we don't have those protections for, against at-will employment, that it actually erodes all of the other rights that we have gained over the course of years through the struggle in labor. But specifically about, why we decided as Raise the Floor Alliance and our worker centers and our coalition to pursue this endeavor, this fight in the state of Illinois, was back in the summer of 2019. Raise the Floor Alliance asked our worker centers, and just for folks who don't know, Raise the Floor Alliance is an alliance of worker centers around the city of Chicago, county of Cook, the state of Illinois. And we asked them, what was the biggest impediment to workplace organizing, demanding better pay, better health and safety standards, calling out wage theft? What makes it so hard to demand all of those things that workers absolutely need? And every worker center, from those who dealt primarily with domestic work to those who dealt primarily with restaurant work, all said, well, everybody's scared of getting fired. That chilling effect of at-will employment is so strong, it's so serious and so pervasive that at its core, it requires, as Ben has mentioned, that workers put up with substandard pay, dangerous working conditions, and everything in between, because that's the only thing keeping them from sleeping on the street in a few weeks. Is their place of employment. And so we connected with NELP in 2019 to craft this bill. And what we realized was there was a whole host of things, of course, chiefly just cause, that workers needed to keep their jobs secure. At-will protections, definitions of what those protections entail, blacklisting protections, severance pay, and more. And so we wrote the most robust bill for workers' rights and worker job security in the state of Illinois, and I would argue the country. And we introduced the bill last year in both the Illinois House and Illinois Senate. And we are running concurrent bills currently. We've gained 27 supporting organizations. It's a powerful coalition of unions, worker centers, policy organizations, and community groups that are dedicated to pushing this bill. And we have definitely stirred up a lot of conversations in our capital and among media, because this bill would fundamentally shift the dynamic between workers and employers in the state of Illinois and send a reverberating shock, I think, across the country. So on top of gaining support, we've also gained our fair share of enemies. Almost every employer group is against this bill in the state of Illinois because of course they are. The system of capitalism that we live under and that they hold up rewards like this intent of malice and that chilling effect that employers can create that keeps wages low, keeps health standards cheap and ineffective. And if you're an employer who doesn't care about their employees and sees them as fodder, as something that can be burned and churned at your will, having at-will protections is a threat. It is a threat to your power. And in reality, I'm happy that we are creating that threat. But the best thing about this whole campaign, I think, that we've been engaging in, Lane, is that there's no reasonable argument against this bill, against at-will protections, right? And I know this because I've sat across from our opponents in the state legislature as we debated this and heard their arguments. And a lot of it boils down because, when you're saying that people should not be able to be fired for no reason, what is the legitimate argument to that? We heard a lot of, well, we don't want to lose the power to fire employees for no reason because the power to do that makes things really easy. Yeah, it does. When you don't have a semblance of concern for the lives of working people, it makes things way easier when you can fire them. And right now, we're in a phase of this campaign we're trying to ramp things up for the next legislative session. And we know this is going to be a big fight, but we want to raise the public profile of this legislation and make this a model for what other states can do across sectors. We want to be more agitational. Lawmakers have had an opportunity to chew on this. And so we were hoping to see some real engagement and action on this next session. And our hope really is that our Worker Centers coalition members will really drive this campaign through worker organizing. We need to show legislators and the public just how pervasive this issue is, because everyone has experienced some form of it in some way, shape, or form, or knows someone who's experienced something like this. And we're trying to raise the public profile through actions and campaigns focused on supporting this bill. So that's kind of where the campaign is and where we're planning to go. I'm happy to share more as we move on through the rest of the program.
Thank you. Yes, I think that folks are probably going to want to hear more about what's happening in Illinois. So Guillermo, you live in a different world, employment world, than what these folks in the US are describing. Tell us a little bit about how this works in Portugal. And I know that you in particular have done work to strengthen the law there. Can you tell us a little bit about the regime there?
Thank you, Len. Thanks for having me. Thanks for this invitation for Kalamovitz Initiative and the Georgetown University. And you are right, we follow a totally different legal system when it comes to employment and to dismissal of the employees. Just to give you a short background, Portugal is an European country. It belongs to the European Union. Its borders are with the Atlantic Ocean, so we are on the west coast of Europe. We are a liberal democracy based on democracy, dignity, the will of the people. But we also pursue the so-called European welfare state. Basically speaking, the European welfare state means that more than providing negative rights to the people, such as private property, right to privacy, private autonomy, freedom of expression, we also, or the countries also tries to give to the people social rights, such as, for example, public education, public health care, public housing for poor people, and also the net of social security in case of illness, in case of unemployment, or in case of retirement. And when it comes to employment, we expressly, the Portuguese constitution expressly defends that the employee is the weaker part of the contract, and as a consequence, it should be treated like that, and it should be protected with a huge floor of rights regarding the employment relationship. Paid holidays, minimum wage, limits to the working period of time, parental rights, and so on. And about the dismissals, actually, you are totally right. We do not follow the employment at will doctrine. And contrarily, we have a legal regime that states that the dismissal without just cause is totally forbidden, is prohibited. And actually, that principle, the so-called job security principle, is inspired in the ILO Convention of number 158 of 1982. And it is also inspired on the European Charter of Fundamental Rights of 2002. And so we have in our constitution and in our labor code, the prohibition of dismissal without just cause. So while the employee is totally free to dismiss freely from an employment relationship by previous notice, the employer cannot do it. He can only terminate the contract based on just cause, based on the so-called subjective just cause, i.e. based on a misconduct or a fault committed by the employee. And so the regime is totally different from yours. And when you first said to me that you have the employment at will doctrine, it seemed to me very weird, because for us, it's totally clear that to provide some stability to the employee, to provide some, well, the well-being of the employee, we have to have this regime, and we have it, as I said, both in the Constitution and also in the labor legislation in our labor code. We have a notion of just cause. We have firstly the prohibition of dismissals without just cause, and secondly, we have a notion of just cause. If you want, then later on, I can show you our concept or notion of just cause. It is based on a major concept, and then the lawmaker tries to exemplify by giving some examples of just cause. But for us, it's totally clear that the employer cannot dismiss the employee without just cause, and by doing it, the dismissal is considered null, void, and the employee has the right to be reintegrated, or if he opts, has the right to receive a severance compensation for the dismissal without just cause. And moreover, more than have the need to have a motive, a just cause to dismiss, the employer has as well to start a disciplinary procedure to dismiss the employee. So he must have firstly a reason, a motive, a just cause. That is the substantive requisite. And secondly, he has to start a disciplinary procedure with an accusation phase, a defense phase, in which the employee is free to defend herself or himself against the accusation. Then he has to get some evidences. For example, if the employee asks for some witnesses, the employer has to hear those witnesses. And then we have the final decision. And the final decision can or confirm the accusation, or confirm or try to close the process if the instructor thinks that the defense was a good defense by the employee. So in a nutshell, it is totally different. There is a prohibition of dismissal without just cause. And to have a just cause, the employer has firstly to have a motive based on a misconduct by the employee. And secondly, he has to start a disciplinary procedure. If he fails, or to have a just cause or a motive, or if he fails, even if there is just cause, if he fails regarding the disciplinary procedure, the dismissal will be considered void, null, and illegal. So as you can see, it is totally different, and we can discuss it later on.
Yes, that is very different than what we are describing here. And thank you for telling us how it works there. And I know that you have done work to strengthen that law.
Yes, right.
So, Ugo, I had a question, a follow-up for you. You mentioned in your remarks that, you talked about how just cause would some sort of fundamentally change the employment system, because just cause employment would change the power dynamics, right, between workers and employers. So I wonder if you can say a little bit about those power dynamics, both at the workplace, but also in workers' whole lives, right? How does at-will employment undermine workers' lives even beyond the workplace, in your experience?
Sure. So we don't think about this a lot, but the power to fire someone is an immense power. It is an incredible power that I think when the roots of the idea of workers being at will in the United States in labor law became a thing, it was equated essentially to an employee's ability to quit. That if an employee is able to quit whenever they want without notice, that an employer should be able to fire you whenever you want without notice. But those two things are not equal at all. Because when an employer loses an employee, they can hire someone else, and it's very unlikely that in between the time that they're without the employee and they get a new employee, that their business is going to go under. it is very unlikely that it's going to happen. And frankly, a lot of the times, employers will just like not fill the position for a very, very long time and make someone else do that work, right? But when an employee loses their job suddenly, they all of a sudden have to deal with the fact they're not going to get a paycheck in 2 weeks. We need to remember that around 40% of Americans are quite literally a missed paycheck away from actual poverty. The power to fire someone and put them in poverty is a terrifying ability, and no worker wants to test that, especially those of us who are not unionized. For most workers, there is no union to protect you from the firing. There is no group that's going to fight for you. You're all alone against that absolute power of the boss to determine your employment situation. Now imagine that fear, that chilling effect is gone. Imagine you don't have to think about that anymore. Think of how many times anyone has gone to work and not spoken up about the smallest things because you're afraid of losing your job. Now you can bring up the fact that your salary is less than your male counterpart, and you asked him about how much he's making. You realize you're making $5,000 less for not really any actual reason. Now you can bring up the fact that hey, your coworker has been coughing and sneezing, and there is no social distancing instituted in this workplace at all. Now you can demand the things that you need as an employee without wondering, will I be able to put food on the table in 2 weeks to feed my kids? And that is an immense power shift, because now you can do just the absolute regular things that you should be able to demand in a workplace, because now you don't have to worry about being fired anymore. And I think that is a huge power shift that would happen if we were able to pass a law like just cause protections.
Terrific, thank you. I wonder if any of our other panelists want to weigh in on this issue of power dynamics, both at the workplace and in the community and the larger impacts.
I mean, first of all, echo what Ugo said, because I completely agree. On the employee activity outside of work, you know, the at-will regime entitles employers, as we've all been saying, to fire workers for any reason at all that's not otherwise prescribed by law. That means that an employer who objects to an employee's political, associational, social activities outside of work can fire the worker for engaging in them. There are some legal restrictions on this, but they're few and far between, and they're not well enforced. And so a just cause rule would presumably disable an employer from relying on an employee's, you know, out of work social political activities, and therefore free up the employee to live the out of work life that she wants to live. You know, the other thing I think it's worth mentioning, just going back to where Irene started us, the idea of a cultural shift. I mean, the legal shift is critical, but the cultural shift is in some ways more important. And, you know, just the idea in an at-will world can be distilled to, you know, the employer can fire you if the employer wants to. And in a just cause world, it's not that. In a just cause world, the culture of the workplace is one in which the employer can't fire you unless the employer has a really good reason. And that shift is important for the power dynamic that we've all been describing. So there's a cultural shift I think we anticipate broader in society, but also a cultural shift in the workplace that has a lot to do with power.
Len, just to add, for us that cultural topic is obviously very, very important, because in our society, everybody defends the prohibition of dismissal without just cause. And even the employers, they do not fight against it. The only thing they sometimes ask for is for more flexibility regarding the management power, about the workplace, about the working schedules, but they don't ask to be more flexible or to get more flexible when it comes to the dismissal, because it's cultural, as Ben said, and Ugo already said, and Irene. And just to give you about that, also that idea of prohibition of dismissal for political or ideological reasons, I will just read you the Portuguese Constitution provision, Article 53, it states that workers are guaranteed job security and dismissal without fair cause or for political or ideological reasons is prohibited. So it's in the fundamental law. Then the labor code confirms it, but the fundamental law states just as I read to all of you. Then we have at the Portuguese labor code, as I told you, the confirmation of it. And we have the notion of just cause, Article 351 of the Portuguese labor code. It states that it is just cause of dismissal, the culpable behavior of the worker who, by its seriousness and consequences, makes immediate and practically impossible the subsistence of the employment relationship. And then we have in number 2, some examples: illegitimate disobedience, repeated provoking of conflicts, unjustified absences, false statements regarding the justification of absences, and so on. We have several examples, but the cultural topic is really very, very important, because one of our major values, as I told you at the beginning, is the welfare state. And under the welfare state, everybody defends that the job security is part of the welfare state. It is part of the European welfare state. Just to conclude this topic.
Thank you for bringing that in. Irene, I want to get you into this conversation too. We heard from Hugo about how employers have pushed back in Illinois, and Guillermo explained that the employers are not only under the law, but sort of the culture in Portugal. So critics in the US might say that a just cause standard would increase unemployment or create unreasonable costs. That's what Hugo was saying. What do we know about the potential impacts? And what might you say to some of those critics?
Thanks, Lane. So first of all, just cause protections, this is something that many good employers in the US already do. And what we see is that at will actually protects bad managers often. And that's the main problem. So it's not like nobody in the US has policies, and actually CEOs often have this in their contracts. So it's not totally foreign in the US context. But secondly, we have empirical evidence from the US, that in states where there have been stronger restrictions against firing, employers may face some adjustment costs in the first year, but these costs are very modest in short term. And then we see also in the New York fast food law that was just enacted last year, that really the sky has not fallen, right? And so employers often overblow these fears. But regarding the effect of job protection laws on unemployment, a recent comprehensive review of international literature on this question has concluded that there's no robust evidence that just cause policies have an adverse impact on employment. There is some evidence that workers may face slightly longer spells of unemployment, but overall, historically, across country, there's no evidence that these protections result in higher levels of unemployment. And actually, other economic research has shown that just cause protections have positive societal and economic impacts by spurring greater innovation, more efficient hiring practices, and increased workforce training. So there was a 2012 US study that found that greater employment security protections led to more innovation overall, as well as more innovative effort per employee and per dollar spent on research and development, because employees feel more secure that they will be able to reap the rewards of their innovation. So I think there are benefits, economic benefits that we can look to as well. And then finally, as I mentioned, employment protections spur businesses to invest more in training the workers that they do hire. And there's a recent analysis that found that greater employment protections increase the likelihood that private sector workers receive on-the-job training. And this was especially true for non-white workers.
Terrific, thank you. And Irene, I'm going to come back to you with a follow-up question in just a minute. But I want to remind all our participants today that we're going to open up questions in just a moment. You can submit your questions in the chat or through the Q&A button, but go ahead and send in some questions. Some people have already been doing that. So Irene, I had a follow-up question actually from your first remark. When, at-will employment in the United States affects all workers, everybody, unless you have a union contract, right? Or some other kind of special employment contract. So I wonder if you can say more about how getting rid of at-will employment would actually address racial and gender inequities. Dig in a little bit more on that for us.
Sure. So I discussed this a little bit earlier, but to summarize, I think there are 5 main ways that at-will employment perpetuates racial and gender inequities. First are the racial disparities in rates of unfair firings that I mentioned earlier. So 50% of Black workers and 52% of Latinx workers report having been fired or let go unfairly, compared to 45% of white workers. Second is the limited legal recourse available for unfair treatment on the job, as I mentioned earlier. The narrow definition of what qualifies as illegal racial or gender-based discrimination under existing law is really insufficient to address the many kinds of race and gender-driven unfair treatment that at-will employment invites and that workers face on the job. And then third is the fact that these workers face more hardship after job loss. Female workers are much more likely to be living paycheck to paycheck, and Black and Latinx workers are more likely than white workers to face an extended period of unemployment after job separation, even when the economy is strong. And then fourth is the prevalence, as Ben and Ugo have talked about, is the prevalence of retaliation as a barrier to rights enforcement. And Black and Latinx workers are much more likely to report in surveys both experiencing retaliation and also fear of retaliation being a barrier to enforcing their rights. And then finally, as we've all been talking about, is this issue of power in the workplace. And the at-will system amplifies this power imbalance that Guilherme has said, that's inherent power imbalance between the employer and the employee. And this is to the detriment of all workers, of course, but especially those who already have the least power in the labor market and are most often segregated into the most dangerous and lowest paying jobs. So establishing just cause protections would really go a long way towards addressing these inequities and giving workers of color and women more power.
Terrific, thank you. Before we begin to move to the group's questions, does anyone on our panel want to jump in on that last question or jump in on anything else that we've discussed before we move to questions?
And if I am allowed, I can only add that more than having this job security principle and the prohibition of dismissal without just cause, we'll also have a limitation regarding temporary employment contracts and fixed term contracts, okay? So under the Portuguese law, temporary contracts and fixed term contracts are only allowed if there is a specific motive, a temporary need of the corporation, and they cannot last more than 2 years. After 2 years, they must be converted into an open-ended contract or a permanent employment contract. So these two branches come from the same tree and come from the same principle, which is the job security principle. Just to give you these notes to complement.
And Guilherme, you worked on making sure that those temporary contracts and the precarious employment was brought in, right? This was a change in the Portuguese law.
Yes, that was a change 2 years ago. The temporary contracts and the fixed term contracts were more flexible than they are right now. Okay, they were allowed for 4 years if it was a fixed term contract, or 6 years if it was an unfixed term contract. and employers could use this type of contracts even for permanent reasons when it comes to unemployed, long-term unemployed people or youngsters. And these two motives were eliminated. So today it is not allowed to have temporary contracts for other reasons than the temporary need of the companies, firstly. And secondly, the deadlines, the duration of the contracts were reduced. We had 6 years for a fixed term contract and 4 years for fixed term contract. And now we have 4 and 2 years. So no more than that. And so the idea is to prioritize, to give more attention for the permanent employment contracts. Based on that same principle, by doing that, we are giving more stability for youngsters, for people that start to work, and we are giving more stability that allows them to create and to build their own family, their own dreams, and so on. So you're right, we also changed the law. The change of the law was called the Decent Work Law, and we tried to put more restrictions on the temporary contracts and on the fixed term contracts.
Terrific, thank you. So we'll turn now to the audience's questions. And I noted that there was someone in the chat who said, I'm late, can I watch it from the beginning? Yes, we will be posting this to the Kamenovitz Initiative website. And we also are going to have it up on our Facebook site because we are broadcasting it live. So you absolutely can access it afterwards. And in fact, we often, I think we're going to even send out a link to this recording to those people who signed up for the webinar. So you'll be able to access it. So I see that there's a question from Paula, who says, does anyone have any data or experience about Montana's law as the only state that has just cause protections? When I worked on this issue, no one seemed to know whether it made any kind of difference, nor could see whether employees know about their rights sufficiently to enforce them. So if somebody knows something about Montana, let's talk about that. But also, Irene, I noted that you mentioned the Fast Food Board in New York, and I wonder if there are other pockets where just cause employment is becoming more of the precedent, or is becoming the precedent in the United States. Is there anyone who'd like to tackle that?
So I will defer to the lawyers on this, but I can say what I know about the Montana law, which I heard from lawyers, which is that it was really, the law was passed, it was kind of pushed by employers to create a kind of a weaker standard than the courts were already using. And part of that was that the penalties were too low, and the damages, so the private bar has been very reluctant to take on any cases for that reason. That's my dumbed down understanding, but I certainly defer to others. And then, so other than New York, Philadelphia actually passed a just cause law for parking lot attendants in 1999. And both Puerto Rico, and I think Puerto Rico also has a law that's been in place for many years. So there's not a lot of sort of empirical evidence yet. We're working to study the New York law. It hasn't been in place for long enough to have enough data yet, but hopefully we will be able to have more data to report on soon.
Okay. Anybody else on that one? Okay. So let's see. I see a question from Bill in the chat. Can you comment on, quote, constructive discharge / dismissal? Is there anybody who wants to comment on that?
I can speak on that. As it's for folks who don't know, constructive discharge and constructive dismissal is when an employer won't outright fire you, but they'll take steps to make it so that you'll just quit on your own. And that's a very common practice in places where there may be some kind of at-will protections or something of that nature. And so we actually in our bill, the Secure Jobs Act in the state of Illinois, that's why it's so important that we made a bill that isn't just defining what just cause is, but there are other provisions in the bill that kind of codify the job security that we are hoping to give workers. And in the bill, we basically outlaw constructive discharge. You make it illegal to do things like demotion and creating a hostile work environment, reducing hours to essentially zero, and things like that. Obviously, in some form of retaliation or for some reason that is actually not given, because employers, yes, will use that as a way to get you to fire you without cause. And if that isn't in your bill, then that's what they could do, because it's something that's employers do very often, is they will just zero out your hours and you will never come back in for work again, but you're not fired technically. So, in the bill, we have a provision to make sure that is outlawed. Anyone else wants to speak on constructive discharge, feel free, of course. Hopefully that answers your question.
We have two questions from Rick, and I don't know if it's the same Rick. Rick asks, he wants to know about the relationship of just cause and union organizing. Rick also wants to know what will happen if the bureaucratic and legal process of enforcing just cause takes months or years to resolve. Does anybody want to weigh in on any of those questions?
Sure. As I alluded to in my response to Lane's question, just cause protection is a way of bolstering a host of legal protections for rights at work. Everything from minimum wage and overtime to anti-discrimination to family and medical leave. These are rights that workers have, minimum basic protections that workers have that depend for their viability on workers' willingness to assert their rights under the law. And just cause protection, for the reasons that I alluded to at the outset, makes it much more feasible for workers to assert their rights under those statutes. That's true of the right to union organizing as well. We all know that since 1935, workers in the United States have had a legally guaranteed right to form and join labor unions, and that formal right has been interfered with from the outset, and acutely so in modern times. The fact that the National Labor Relations Act makes it illegal for an employer to fire someone for union organizing activity doesn't stop employers from firing people for union organizing activity. In fact, something like 1 in 5 workers who takes a lead role in a union organizing campaign gets fired for doing that. Just cause protection is not a silver bullet, but it would make it harder for employers to fire workers for union organizing activity. And as it did that, it would empower workers to organize, just like it would empower workers to demand minimum wage and overtime and their rights under the anti-discrimination statutes. I think Ugo wants to take the one about enforcement.
I can tell you some words on that based on the Portuguese law again. And under the Portuguese law, we have deadlines. So firstly, I cannot start a disciplinary procedure to dismiss with just cause based on facts that occurred more than 1 year ago. So I have 1 year. Secondly, after the employer takes acknowledgement of the infraction, of the misconduct, he has 60 days to start a procedure under that period of 1 year. And after the beginning of the disciplinary procedure, it has to make a final decision within 60 days. So we have deadlines, and for that reason, it is not possible to go and limit it with a disciplinary procedure. Now, secondly, about the unions and the collective agreements and the legal regime of the dismissal with just cause. By tradition, by default, we admit that the collective conventions can replace the legal regime stated at the laws, but only if they are more favorable for the employee. And so about, for example, the prohibition of dismissal with just cause, the Portuguese provision 339 of the Labor Code states that the regime regarding the dismissal with just cause is statutory and imperative, and it cannot be replaced either by employment contract or by collective agreements. So it is an imperative regime, and so we do not have collective dismissals. Yes, we do not have collective bargaining regarding the collective and the dismissals of the employee regime.
Great, thank you. Ugo, you want to jump in on what would happen if the bureaucratic and legal process of enforcing just cause takes forever to resolve?
Yeah, I think that Guilherme mentioned some points that, about deadlines that I think are important in regards to the, at least the beginning of the process in which, the reason behind firing an employee has to be furnished immediately within like 3 days of like the infraction when you are firing somebody. But of course, the bill that we have in the state of Illinois, creates an administrative process through the Illinois Department of Labor. And the problem here is that you can't set deadlines in the same way at the department within this law, only because of the fact that I think historically across the country, departments of labor are underfunded, and they're not really given the resources necessary to be able to meet deadlines on time a lot of the times in regards to legislation that's being passed. So, if we were to say you have 30 or 60 days, Department of Labor, to resolve such and such case, or 3 months or whatever it is, it could be possibly very hard for them to do so, because they may need a certain amount of investigators that know how to deal with this particular issue, and so on and so forth. So, as much as we can, in working with our Department of Labor, and if you're thinking about doing a similar bill like this in the state that you're in, obviously it's a conversation that needs to happen with the department about what is possible and what is not. Something that we made sure as we moved through that process was also creating a private right to action in the bill. So for folks who do not know, private right to action is just your ability to be able to, as a private person, be able to sue in the name of the law. And so, we recognize that sometimes going through the administrative process may not be quick enough, or the Department of Labor may be swamped with existing claims and things like that. And so the individuals are able to sue in the name of the law and go through a court to get to be recuperated for whatever losses, whether it is wages or wanting to be reinstated into your job or something like that. So that is a way kind of around the length of the bureaucratic process. But of course, the bureaucratic process is encouraged, and hopefully we can get to a point where our departments of labor are fully funded, fully resourced, so that they can take in the volume of whatever amount of cases will be coming in under these kinds of laws.
Just the initial experience from New York City fast food is that they're not being, and we're in touch with the enforcing agency there, and they're not being flooded with cases that they can't handle. I think they just processed the first one and in favor of the workers just a few months ago.
So we're hearing a number of cases in the US and in New York, and the parking attendants in Pennsylvania, the bill in Illinois. I'm curious what our panel would say in terms of if people in our audience are wondering, gosh, what's the next step in this movement? How can change happen? I wonder if our panelists can weigh in a little bit on your visions on how change can happen on this issue.
I think what's exciting about this issue is that it is, it's something that localities can take on. So cities, much the way that the Fight for 15 really started at the city level, this is also something that cities can take on in addition to states. So I think, and it is a very, it's a natural progression, I think, also from the Fight for 15. So I think if we can continue to sort of popularize this issue for folks to start campaigns and to really, I think that, it's very intuitive, I think, for workers that we've talked to. This is something that people really get and understand why we need in this country. So I think the more that we sort of start talking about it and we can catalyze these campaigns, I think we're primed for it to really take off in this country.
And the only suggestion I can give to you is try to compare with other countries. Obviously, the US is an amazing country, a coast-to-coast country, is an exceptional country with brilliant people. But even if you believe in the US exceptionalism, don't forget that in Europe, we also have democracies. But democracy doesn't mean that we cannot try to reach a welfare state. And in all the continental European countries, we follow that prohibition of dismissal without just cause. And Europe is not a communist regime, as you know, it's a democratic regime. But even though we have a different culture when it comes to that doctrine and to the protection of the employee. My only suggestion is that, because I do not live there.
And I would obviously defer to Ugo and Irene and the organizers and the campaigners on this. But in terms of the cultural shift, one interesting feature is that, at least according to the data I've seen, if you ask working people, can they be fired at will, most of them don't think they can be. It seems kind of crazy to them too, in the country. And so there's something in that, in terms of the political work that lies ahead and the important political work that's already going on. We don't have to convince workers, I think, about the justness of just cause, and so that's probably to our advantage.
And the polling data really reflects that as well. It's just broadly popular across political party. The majority of Republicans support it in rural areas, suburban areas, urban areas. So it's just very, very broadly popular. And I think that the fact that it also impacts, across class as well, right? And across, all kinds of jobs. I mean, we see, reports that in the Amazon corporate workplace, they're using the system of rank and yank. I don't know if folks are familiar with that. That's if you are not performing within the top X% of your team, then you're just automatically fired. This was sort of popularized by Jack Welch in the 80s, and Amazon is sort of bringing it back. So people are affected by this this kind of toxic work culture, I think, not only just in all parts of the labor market. So I think, if we starting these campaigns, we'll see that we can find lots of unlikely allies as well.
At its core, I really do think that, in my role with Raise the Floor Alliance and the work that I do outside of it, it's going to come down to organizing at the end of the day. This is going to be a ground up movement that is going to have to be huge, because as we've said multiple times, this is going to be a power dynamic shifting piece of legislation, federally and locally, wherever it's going, where people are pushing for it. And no one who is in power likes to lose power, right? So we are going to have to build large coalitions across the country, across the state, here in Illinois, to be able to make this bill a reality. Because when people realize that they don't have this protection that keeps them, again, from living on the street, it keeps them from being able to put food on the table. When they realize that this is this constant level of jeopardy and this constant level of fear, people will stand up, I think, and realize that this is something that should be commonplace, that we should be putting to make sure that we're protecting the livelihoods of workers across the country. And so I think it's winnable, but it's obviously it's going to take a huge groundswell of support everywhere to make it happen.
Terrific. With that, I think that is a great way for us to end this discussion, to conclude this discussion of thinking in a different way, envisioning an employment system in the United States where there was a just cause standard, where it was embedded in our legal system, in our cultural system, and as Guillermo urges us to do, to think globally and to think about other contexts in order to give us that perspective. So thank you to our audience for coming today. Thank you to each of our panelists for bringing your ideas and your words today. We will have the recording up on our website and we'll send it out to people who registered. And in addition, stay tuned for the new social compact projects convening June 2nd and 3rd through the Kalmanovitz Initiative for Labor and the Working Poor. It's called A Pandemic Worker Wave and a New Social Compact, a public forum on working class prosperity in a transformed world. So you won't want to miss that. Thank you all for coming today. And that concludes our event. Thank you.
Thank you, Len. Bye-bye. Aren, Ben, Ugo, thank you so much. Bye-bye.